everybody, welcome to part 2 of Supreme Court cases. They're great for thematic and DBQ essays. Woo! And there's our good friend Larry the Pencil. He's the one that's reminding us that they're great for thematic and DBQs. So if you doubt me, don't doubt Larry. Larry knows what he's talking about. Just want to remind you guys that I have set up some flashcards for you to look at 24 of the biggest Supreme Court cases on Quizlet. All you have to do, go to quizlet.com/Mrs. Clemens. Oh, look, it shows up right there. That's so cute. Oh, okay. Well, anyway, so what you're going to do is you're going to go on there, and what you'll see is that it comes up and it says both sides. That's not a real flashcard because it's showing both of them at the same time, so you might want to click off so you just see the word, and then you can be like, what is Marbury versus Madison? Oh, yes, established judicial review. Also, the terms are all there underneath, just for your lovely looking pleasure. There's a game section. I haven't played that too much. Maybe you'll be the awesome person with it. And then there's even a place to leave messages if you want to. Alright, so we're going to talk about, during this little segment here, equality under the law. Let me just tell you, these cases that we're going to talk about are phenomenal to use for outside information. Hey, did I say phenomenal? I mean awesome. Did I say awesome? I mean super de-duper amazing, Captain Crazy. If you don't use them, you're crazy. Yeah, something like that. Anyway, seriously, keep Supreme Court cases in mind to use as outside information in a DBQ. Oh my gosh, I gotta tell you, every time you use a Supreme Court case as outside information in an essay, an angel gets their wings, or something along those lines. Maybe I get wings. Or I just drank Red Bull. But regardless, something good happens, okay? So please, please, please remember your Supreme Court cases. They're good and good for you. Alright, so the first one, well actually, before I even say that, some of these cases, when we're talking about racial equality here, the first three, Scott, Plessy, and Koremitsu, are sort of the sad ones, alright? The we're going to cry cases. Luckily, we get vindication with the last three, the Brown, Heart of Atlanta, and University of California. So these are great to talk about, even if you're talking about change over time or sort of the evolution of viewpoints in the United States. They're just phenomenal. Did I say phenomenal? I did. Remember it. All right. So our first one is Scott versus Sanford, and that's the case of Dred Scott. And as you guys remember, Dred Scott, he sued for his freedom. He thought that since he was taken to a free state, he was free. Yay! Goes to the Supreme Court. And this is, like I said, a very depressing and sad case, where basically the Chief Justice says, yeah, dude, yeah, you're not free. You're property, okay? So if your master wants to take you to anywhere in the world, you're still property, because you were bought and paid for, which is pretty sad. Then it says, yeah, you know what, and you shouldn't have even been allowed to sue in court because you're not a citizen under the law. Now, luckily, he did say that, and I'm saying luckily because it gives us a cool constitutional thing that happens. Oh my gosh, it's saying restart now. I don't want to do that. I want to postpone. I gotta postpone 4 hours. Huh. Alright, anyway. So you get a super cool thing that they say that they're not citizens, but what's awesome is it gives the abolitionists another thing to kind of work on during the Civil War. Remember when we went to go see Lincoln? I know, it was good times. So not only do they push for ending slavery, the 13th Amendment, but they also push for the 14th Amendment. And the reason why they push for the 14th Amendment to grant citizenship to the former slaves is in direct relation to this case. So, great thing to mention would be Scott versus Sanford and how it eventually led to the 14th Amendment. Hey, did I say 14th Amendment? Yes, I did. And then it also talks about how the Missouri Compromise is unconstitutional. Thanks, guys. All right, another one of our super just meanie cases is Plessy versus Ferguson. So now this takes place after the Civil War, after Reconstruction, and during Jim Crow time. And in this case, basically, this poor guy is trying to ride the train in the nice seats as opposed to the crummy seats, and he gets in trouble for that. And so the case goes up to the Supreme Court, and this is where you get one of those rulings that you scratch your head at. basically they say, yeah, we can totally have separate facilities for blacks and whites. We can have separate restaurants, we can have separate schools, we can have separate train cars, we can have separate everything as long as they're equal. Now here's the thing. Did they know it wasn't equal? Of course they knew it wasn't equal, but they kind of buried their head in the sand. They say it's not equal. And so this, here we have this ruling in the 1890s, and hold on to it for a second because we're going to come back to it in a sec. All right. Koremitsu versus the United States. This is a case that happens during World War II. And the thing we always link this with is how during times of war, Americans have had their civil liberties kind of taken away a little bit. So we link that with the suspension of writs of habeas corpus during Lincoln, during the Civil War. We link that with the Sedition Acts, which took away freedom of speech during World War I with Shank versus the United States. And now we add in the fun and excitement of basically targeting people based on their race. You guys know I'm being sarcastic. It's not really fun. It wasn't exciting. It was really pretty sucky for the people that were involved. Now, what the U.S. government did finally do in the late 80s was say, oh yeah, we're totally sorry about that, and grant the survivors $20,000, which isn't a lot for years, spent in a camp, all of their possessions taken away, including their property, homes, businesses. So, pretty crummy. So this is good if you have something where it talks about two groups. Then you can obviously talk about African Americans, but you can also talk about Japanese Americans. Now remember I told you guys, hang on a second to Plessy. Well, hang on to it for Brown versus Board of Education of Topeka, Kansas. This is where we start to have the, oh thank goodness, life doesn't suck case. And so, yeah, what it says, I just love my computer today. What it says is that no, Plessy is totally wrong. The separate is inherently unequal. And think about it, guys. Just imagine your life if you only went to school with people of your race, regardless of what kind of books or teachers. It's not equal. It's not fair. It's not good. And so this says, no, we have to desegregate schools. Now, some stuff that's great to talk about along with this is Little Rock High School and how Eisenhower had to send in the National Guard. It's great to talk about how eventually, even then, segregation was really slow to end in schools, so they start busing programs. And I just read an article today talking about how Chicago is more segregated than ever. So this is great to talk about sort of the evolution and how things are still kind of going on today. All right, Heart of Atlanta Motel versus the United States. What this is talking about, basically, so we have Brown in 1954. Then we have 10 years later the Civil Rights Act of 1964, which says you cannot segregate public facilities. And so, of course, Heart of Atlanta Motel tries to deny people entry, and so this goes up to the Supreme Court and upholds the Civil Rights Act of 1964. Some great stuff to talk about along with that is obviously, that in 1963 is when you have the March on Washington with I Have a Dream by Martin Luther King Jr., that along with the Civil Rights Act of 1964, you end up getting the Voting Rights Act of 1965, which ends literacy tests. You get the 24th Amendment, which ends poll taxes, so some good stuff. University of California versus Bach. Now, what this is kind of a continuation of this whole school thing, where they start affirmative action, and it's pretty controversial. But what this rules is, yeah, you can use affirmative action in terms of admission to college. And it says it's okay. Now, obviously, affirmative action went through some changes over the years, but this is the first case that, sort of affirms that. All right, so this is an actual Regents task from a couple years ago. And so what it says is identify 2 reform movements in the United States since 1800. And for each reform movement, you have to do the following here. You have to describe the historical circumstances that led to the need for the reform. You have to talk about 1 goal of the movement and 2 actions taken by the government or the group or an individual. So you have to have a goal, like end segregation, and then 2 actions taken to end segregation. And then evaluate the extent to which the reform movement has made an impact on the United States. Oh my gosh, guys, if you're not talking about civil rights, dude, talk about civil rights. All right, so so what I picked here for our purposes said so women's suffrage is really good. Now, why am I not talking about it right now? Because there aren't Supreme Court cases that I want to do with this. I want to talk about these. So I'm going to talk about the civil rights movement. Now, again, these are just really quick little notes. So I would talk about the historical circumstances of the Jim Crow laws, how they were passed after Reconstruction, how they limited all kinds of things in terms of where people could live, where people could travel, who they could associate with, all kinds of things like that. And I would definitely talk about Plessy versus Ferguson, that basically upheld the Jim Crow laws, saying segregation, A-OK. All right, then a goal of the movement would be obviously to end segregation. And so 2 actions, these, remember it said it could be individuals, so obviously you could talk about Martin Luther King and the Montgomery bus boycott, you could talk about the freedom rides, you could talk about the sit-ins, but this is Supreme Court case review, and so obviously I'm going to talk about Supreme Court cases. So we've got Brown v. Board, Heart of Atlanta, that you would explain. Swear to God, if you just mention them, I'll be really upset. You need to actually explain them. And then the impact on the United States. Well, gosh, guys, as a result of these 2 cases, you get overall desegregation. Brown starts with schools, Heart of Atlanta starts with everywhere else. We were talking about busing to actually make desegregation in schools happen. Without that, you wouldn't get affirmative action. Without all this, you wouldn't get African Americans actually being elected into offices, whether it was mayor, whether it was state legislature, or, House of Representatives and the Senate. And obviously, guys, talk about it. Whether you like him or not, talk about President Obama and how he's a part of this, that, maybe that wouldn't have happened without these cases. All right, well, that's all for right now. Stay tuned for our next section a little later.